When you're up against a hostile room of people who don't want to be there, you need real strategies that get results. Welcome to From Hostage to Hero, the show that gives you practical advice you can use right now in the courtroom, boardroom, or classroom. Learn how to move your unwilling audience to one that is invested in what you're saying, eager to participate, and engaged in the process. Learn from the attorney whisperer herself, your host, Sari Delamont.
Well, welcome everyone to another episode of From Hostage to Hero. We have back in the house Jody F'ing Moore. She's changed her middle name to that. You have, right?
I have officially, and
officially.
I'm still in the basement.
Hopefully not for long. We're going to hopefully get some office space here in the next new year. But we also have brand new, she's been Coach Marlo in the crew now for the entire year of 2024, but is now our chief collaborator, Marlo. I keep wanting to say Thomas, but it's Marlo Arnold. I mean, forever I want to say Marlo Thomas every time. I think it's the only other Marlo I've ever known. How common is that name, Marlo?
Not very common, although Coach Jody and I were somewhere a few weeks ago and we checked into the hotel and someone told me that their mother was also a Marlo.
Oh, that's right. Yeah, you did say that. So I'm not that weird that I think that's...
It's pretty uncommon.
Yeah. So tell us about your new role at H2H in addition to being coach and consultant.
So I'm so excited to be starting this new role where I am the collaborator in chief here at H2H. So I'm going to be kind of the point person with crew members and people who are thinking about getting into the crew and coordinating events moving forward. So if anyone has any issues or problems or wants to reach out, feel free to email me at marlo@saridln.com.
Yes. We are so excited that you're here.
And I'm finally on a podcast. I've never been on a podcast
I
before.
know. Crazy.
What's up with that?
Crazy. Well, before we get going and talking about what we're going to talk about today, we have to talk about the fact that you're both wearing the same jacket in different colors.
Yeah, they can't see that though.
They can. No, but if they're watching, because this is actually, and you guys have to watch, that we're telling you all these things because I made the decision for some unknown reason to try bright blue eyeshadow for the first time. And then I paired it with light pink. So if you want to see Sari in the 80s, you want to definitely tune into the video part of this podcast. I don't know why I didn't try that before, like going grocery shopping or, on the podcast.
I like it. I think it looks good.
Well, thank
you.
you.
Goes with your earrings and your glasses.
I'm one of those people that's like, oh, I'm wearing blue today. Let's make everything blue, which I don't think is what you're supposed to do, but I did it. So tune in and watch that. All right. Today we are talking about how to unfuck your witness. No, unfuck your witness prep. That's what it is. And Jody came up with that title. She totally did, and she's embarrassed. So what we're talking about is witness prep and how so many of our clients and people are doing it wrong. Why? Why, Jody and Marlo? Why are they doing it wrong?
Well, let me just add a tiny bit of clarity because when you say witness prep, it's I want to clarify. We're not talking about plaintiff's witness prep.
Right,
That'll be another episode. We're actually talking about expert witness prep. So one of the things that we have been asked to do from time to time is, can you help us get our expert prepared for their trial testimony? And so Marlo and I had the opportunity to go and work with an expert, and we had all these, insights and brainstorms because we were collaborating.
Yes.
And we thought we need to bring this back to the crew. So your question, I think, was, well, what are we doing and why is it wrong?
Mm-hmm.
And so Marlo and I were chatting about it, and it's like, okay, well, how does a lawyer typically approach the expert witness prep?
Mm-hmm.
And one thing I think happens is, oh, this expert, they've done this a ton of times. They know what to do. As long as they've got the content down, we're just going to wind them up and let them go.
Mm-hmm.
So it's sort of the first thing we're doing wrong is sort of we're doing nothing to actually prepare the expert for how we want them to testify or what role we want them to adopt when they're testifying. Fair enough?
Absolutely. And then the second thing I think that people are doing wrong is they're overdoing it, right? So Jody went over the underdoing it, but also we'll script our questions and we'll script the answers for the expert. And so we're over baking sometimes this expert witness prep by creating a script.
And why do you think people do that?
Why do we think we're scripting?
Yeah.
I think that we think we're scripting because I can tell you from experience, right? It's really hard when you get to the expert phase of a case because this case has been my baby, right? For a year or 18 months. And I know everything there is to know about it, right? I've taken the depots, I've gathered the evidence, and I know that I want these 10 points to flow perfectly out of the expert's mouth, right? They have to have this opinion. They have to back up this opinion. They have to anticipate the challenges. And so in that respect, I'm going to write out every question and every answer and every topic so that we don't miss something. So again, I think it's sort of that fear base and a lack of trust that I'm actually going to have a conversation with my expert, and I'm going to invite the jury into the conversation, and we're going to talk a little bit about how to do that. And I'll also note, when I just said that I have 10 points that I want to make with this expert, if you've been listening to the last few podcasts, that's probably too many points to make.
Right.
So again, we need to get really clear on what is the role of the expert and what points do we absolutely have to make with this expert, and then go into prepping for the trial with those pieces of information in mind. But again, we over prepare because we're scared that, we're going to miss something, or because we're attached to the information that we've developed and we want to give that information to the jury.
What's the danger in over preparing? I mean, I hear that under preparing, it's like, well, they know what they're doing, so, just let them do their thing, which if my experience is any guide, so many of you are like, oh my God, I had this locked. And then the expert just took a shit on the stand. I mean, they just couldn't communicate to the jury in a way that made any sense. They were so, especially for, experts in general are so into their expertise that they don't know how to talk to the everyday human. And so that's obviously a problem to underprepare them, because we think, oh, they'll just do what their thing, which obviously not always is the right thing. But what's the danger in overpreparing them and creating kind of a robot?
Well, and just to be clear, we're not suggesting that people not prepare, right? The issue is not practicing, right? So if we're scripting something out, then if someone's just reciting a script, they're not really connecting with the jury. There's no genuine connection there. The level 3 is very flat, right? So, so the over preparation can almost be as much or worse of a problem than under preparing. But we do think that one of the things going wrong here is the lack of practice, right? So if I just send someone a script via email, I don't have to sit down and practice with them because they have a script. They know exactly what to say, right?
So it's a time saving measure in many ways.
Yeah. And I also think the script, it hamstrings the attorney and the witness. And so it comes off as either performative or inauthentic.
Which is why we don't have people memorize their opening statements.
Exactly. And so it's almost like the script can be used as a crutch. Okay, now that I know that I need to make these 10 points in this order with this specific piece of evidence, it does come across as sort of robotic. And one of the problems with being robotic is it's sort of uninteresting. So we're talking about how do we tell a story that's captivating an audience and making them want to listen, and a script is not going to accomplish that.
Yeah, I was just kind of thinking, like, who would want to listen to an interview, basically? Yeah. And the best ones are the ones where it's really give and take, and it's very, very interactive, and it doesn't feel like, okay, I've rehearsed my side, now you say your side, now I say my side, now you say your side. That's not how it works.
Right. And God forbid you skip something or you skip ahead, right, to a question. It's taking the attorney and the witness sort of out of being present and being grounded. And here are the topics that we want to cover. It reminds me a lot of voir dire. We talk about in voir dire, here are the topics that we want to cover. And we might have a context statement. Well, now we're going to talk about safety while driving, right? But we have different ways that we might go with that conversation. But if we've scripted what we think our voir dire is supposed to look like, we might skip a really juicy part of the testimony because that's what came up organically, because that's not in the script or that comes later. So we want to make sure that even when we're working with our experts, that we're understanding the bigger picture and what points or principles we need to hit with this witness, but we're not rigid about how we're going to reach those, at least not in the sense of a script. I think sequencing probably stays somewhat rigid.
Okay, so you said something about practicing, Marlo. Talk to me about the importance of practicing, and how is that different than rehearsing?
Right. Well, it's just what we were circling back to what we were just saying when it comes to not following a script, right? If the expert is practicing and has a list of points that they're working on, then the conversation flows naturally, as opposed to if you're just following a script, then that falls very flat.
why need to practice? If we don't have a script, then why practice? Wouldn't it be more fresh and interesting?
Right. I think the problem with that is we are missing the opportunity to work with our experts and collaborate with them on their nonverbal communication. So that might be fine for a deposition where you're really just trying to get the words out on the page and hit these points so you can show a judge, no, this is what they said if you're opposing a motion or supporting a motion. But in trial, we're really thinking about the conversation with the jury, right? And so part of that conversation is the nonverbal communication. So as we thought about approaching this task of how we would work with an expert and using the H2H method, right, it brought us back to, well, we have the principles of nonverbal communication we have, or of any communication: content, delivery, reception, and mindset. And that's the other thing, is that I think we skip mindset when we're doing expert witness preparation. And we certainly found that to be true in the experience that we had. So that was a big light bulb moment for us, was part of the practicing brought out the mindset issues that were underlying what the expert was saying in a way that we had that incongruity. And we needed to get the expert sort of aligned with what they were saying from a mindset point of view, so that non-verbally what was being communicated was now passionate and compelling and interesting.
Because we've talked about many times in the podcast and in H2H crew about how it doesn't matter how you hold your hands or modulate your voice or any of those things. If you're holding a nonverbal or a mindset problem, that's going to come out in your nonverbals, right? So you got to get your mind right first. So before we talk about the mindset, because I think that's so huge, what are some of the things that you guys have noticed with experts in terms of nonverbal communication gone bad? Like what kinds of things are they doing that we don't want them to do?
Well, again, what are we talking about when we're talking about nonverbal communication? I want to be clear that I'm not talking about necessarily like they're fidgeting or they're crossing their arms. Like those are the more obvious things that I actually think the witness was expecting us to talk about, which we didn't. I mean, we had, 2 minutes of tips and tricks, if you will, at the end, but that was really not the focus of our conversation. I think the nonverbally, the thing that they're doing is they're actually adopting so much neutrality.
Yes.
That they are forgetting that they actually hold an opinion that they think is right, and that they have the receipts to back it up. They have the education, the experience, the qualification. They've reviewed all of the records. They're the most knowledgeable person in the courtroom to support the actual opinion we're asking them to hold. And yet they're conveying nonverbally that this opinion is important and here are the reasons why I'm right. And there's a disconnect there. And it's under the guise of neutrality.
Right. And I just want to add to that this is because of where our experts come from, right? Your expert might be a college professor or a scientist, and what they're used to doing with their big brains and all their knowledge is being neutral and, convincing other people from a place of neutrality. But it's not always helpful to our jury to have our expert, present a menu of options from which the jury can choose, right? The other side's going to present their option.
Right.
Our expert's job is to tell the jury what's right.
Well, and I think this is I'm so glad that we're talking about this, because we've noticed this even in opening statements with plaintiffs that we've worked with, is like they'll deliver an opening statement. I'm like, whose side are you on?
Yeah.
Yes.
And I know that we've always been, you all been trained. We've got to, we can't advocate an opening, but you are definitely standing on one side, the right side, by the way. And when you come off as so neutral, then it confuses the jury. And you guys found that this was also true with this witness that you just recently prepped. And so dig into a little bit more, because I think there was something from the witness who had said something about like the difference between trial and depositions and why they were trying to be neutral when you brought this up with the witness.
Right. So there's a couple points I would make. One is, I'm not saying experts shouldn't be neutral. They should start neutral, right? That is part of the scientific method. But once they've committed to reviewing all the materials and applying their knowledge to actually formulating an opinion, now they need to back up their opinion. So that's one point of clarification I want to make. It is right to start off neutral. I don't know which side of the issue. Once I apply my knowledge and expertise and evaluate the evidence, I don't know which side of the issue I'm going to come down on. But then they plant their flag, they take a stand, and we pay them a lot of money to do that. And then to show up and sort of be like him, ha, and not stand behind it. That's where we get into trouble. The other point that you asked about was sort of like, well, what's the difference between deposition and trial? I will say that in deposition, the mindset can be different. In deposition, the mindset can be, I'm going to hit these points, but I'm maybe not going to be as much of an advocate that I would be at the time of trial because I'm saving a little sort of gas in the tank, if you will. I don't want to give away
Everything.
all of it, right? And I don't necessarily even want to give away the personality that I'm going to have when I deliver it, or I don't necessarily want to give away the analogies, metaphors, stories, vignettes that I might tell in front of a jury, but I'm going to hit my points. And so I do think that some experts will show up in a deposition differently than they show up at trial. And I think the lesson that I would ask the trial attorney who's working with the expert to understand is you should ask that. You should be asking your expert, hey, do you show up differently in deposition and trial? Do you adopt a different mindset, or do you take a different approach when you're answering questions in a deposition versus trial? Because what we don't want to have happen is leave a deposition and think, well, that was kind of a dud, or he waffled on this or that, and think that's the way they're going to perform at trial, if that was intentional or strategic.
Well, I think that so often we settle more cases than go to trial. So I'm assuming, I could be wrong about this, that most experts are used to doing depositions.
Right.
And I think that was true for this one witness that we're talking about versus trial. And so I think more so than even a question is also telling them, right? So this is what we want in deposition, but in trial, we want something very different. Are you able to do that? Or I'm going to help you do that, or we're going to hire Jody and Marlo to come help you do that. But I think that they're so used to being in deposition and not giving away the farm. And then they come into trial and it's like, what was that? Like, I don't even know what side you're on.
Well, I think because we settle so many cases, it's common that an expert has had a lot of depositions under their belt and maybe they've never been to trial.
Right.
So
Exactly.
I've definitely come across experts, this is their first or this is their second time at trial, and they need to be taught, look, there's a difference in how you show up in a deposition versus how you show up in a trial.
Absolutely.
Yeah.
All right. So what we touched on some of these things, but what can they do instead versus underpreparing or overpreparing or not paying attention to? Well, actually, let's go to the mindset piece because you guys have brought that up. Talk to me, and I'm going to go to Marlo on this one since Marlo is heading up our mindset mastery program right now in H2H with Coach K. Talk to me about the importance of mindset in a witness, an expert witness prep, because you said that surprised you. And I think it would surprise a lot of our listeners to be like, really? What does mindset have to do with it?
Well, where we really started in this particular expert witness prep was we started with SCARF. We started exactly where your book starts and where our method starts, because we really felt like part of the issue we were facing is the expert didn't completely understand where the jury was coming from. So we started out by explaining the SCARF model and basically that the expert, just to narrow down on the part that the expert is in charge of or is most important, and we narrowed down on the fact that this jury needs certainty, right? And so it's not helpful to the jury if you expert are just diplomatically offering some different options,
Yeah.
right? Because that doesn't give them any certainty.
They're like, great. If the guy from Harvard doesn't even know, then how am I
we
supposed to do
supposed
it?
to know?
Yeah.
Yeah.
And when you're saying SCARF for our new listeners, that's the brain model that says we can either reward or attack the brain based on 5 factors: status, certainty, autonomy, relatedness, and fairness. And so you're absolutely right that jurors need all of those things, but where the expert comes in is with the certainty piece.
Right.
Yeah.
And it was amazing over a couple of days of working with this particular expert, how often that person came back to the SCARF model and how helpful that was to the expert in understanding that expert's role in trial.
What do you think experts think that their role is?
Yeah, I think that was a fun exploration. I think they generally understand, like, I'm a teacher, I've got to teach the jury. But it's interesting because that perspective changes whether it's direct or cross, right? Because cross comes across, I think, a lot more hostile. So it's more like, well, I can't give away any points, or I don't want to disappoint. They're afraid of disappointing the lawyer or the case. And so one of the things that we really talked about is you can't be a different person on direct and cross. You might answer questions strategically differently, but we don't want who you are to be different on direct and cross. Because again, a jury will see through that. They'll smell it. They'll be like, wait a minute, this guy was all Mr. Nice Guy on the direct, and now all of a sudden he's huffing and puffing and avoiding the questions. So that was a really important thing, which kind of dovetails to the next point, which is in addition to getting the expert to try to understand, okay, well, what's my role, right? So we asked them, in order to give the jury certainty, how do we do that? Well, you have to basically say, I'm here to help you, jury, understand all this information that's come out in this trial so you can make the right decision. And so let me walk you through why this is the right decision.
Well, and I think, and just I was reminded when we were talking about this and debriefing this last one that y'all had, it was such a light bulb moment for the witness to be like, because they think they had to convince.
Yes.
And the minute we go into, and we know this with lay witnesses, the minute we always tell our late witnesses, you don't need to convince anyone. You just follow my line of questioning. You give, when you're on cross, just get, just yes, no, be as little as possible, right? Don't try to help me. That's when we always get in trouble with our lay witnesses. But I think our expert witnesses feel the same way, right? I've been hired to convince, and then that makes them go into this really weird place versus, your job is here to guide the jury to the logical conclusion.
Yes. And in the mindset world, we talked about using the ally, right? So we talk a lot about having sort of saboteurs and inner wisdom, and then we have allies. So who do we want to call forth to help the experts? So we're like, we happen to be working with someone who was a teacher, a professor, and we're like, okay, well, let's talk to your professor ally. Like, how would you teach this to a class? And so we worked on that. And I'm skipping ahead, but what was like super brilliant and like a big aha moment was when we talked about cross. It's like, well, now what's happening? And it's like, well, is like the dean of students coming in and watching you and you're trying to perform in a certain way?
Ooh.
Or is it more like someone like a misguided student? It's like, oh, they're trying so hard to understand, but they're just they just didn't quite get it.
Yeah.
And that really
let me explain it again.
Yes. And that was really resonant for this person. And they were like, oh no, it's the misguided student. And we're like, right, because no one in that courtroom, including the asshole defense attorney who's asking you a bunch of questions that don't make any sense, right? Because it's a highly specialized field. It's just a misguided student to be like, oh, okay, that's not quite right.
Yeah.
Let's try
Good
this
attempt,
again.
though.
Yes.
Yeah.
And that turned the whole, sort of nonverbal. Again, it turned the nonverbal communication
This is
over.
it right here. I mean, this is what we're talking about, how to unfuck your expert
With
prep. Adding the prep there is because this is everything.
Yeah.
Right. The minute that they get what their role is, and I doubt that many people go, what do you think your role at trial is? Which is what y'all do because you're trained mindset coaches when you work with the witnesses. But this changes everything because now they recognize, oh, okay, I know more than anybody in this courtroom. And I think we have to remind them of that.
Yep.
Yes.
Yeah.
And once they were reminded of that, we empower them just like we empower the jury.
Yes.
And now it's okay. I don't have to argue with anybody because I know more than this defense attorney does.
Right.
Yes.
I know more than anybody in this room.
Right. Well, and the safety of the jury, right? So if you have your expert getting confrontational with the defense counsel, then the jury's like, well, hold on, this doesn't feel safe. Right. Or if defense counsel objects to a question and the expert stops breathing on the stand, the jury's like, whoa. Uh-oh, right? So we really worked with this expert on teaching this person that you're seen as a leader here. And so you have to breathe for the jury, even if there's an objection.
There's an
you
objection.
have to breathe for the jury. Right.
What, did you not understand?
Absolutely.
Can I go through that again?
And sitting patiently while the judge deals with the objection. There's a sidebar, sitting patiently and leading the jury and how you deal with that situation.
Yeah, it was really fun. It was super fun.
I love that. Any other tips that we have for expert unfucking your expert prep?
Well, so we have sort of what's the other side of the coin to scripting, right? And so we actually worked on resonant conversations.
Ooh, I love that.
And so in order to get there, we went back to, in the H2H method, right? We talk about what's on our fears list, which is almost always going to show up as a defense point, which the expert needs to be prepared for. And then what's the ideal belief system or what's the antidote to that? And we mine for principles. And so what we ended up doing with the expert was, well, what are the principles that are underlying your opinions that the juries can understand? And there was some complexity to the case. And so we ended up working a lot through storytelling. We went through what are the components of trial. You're either teaching, storytelling,
You're dealing with
or dealing with resistance. So the teaching part, I mean, hands down, like this person could have, read the phone book and I would have learned from it. So that really wasn't the issue, but it was the storytelling. And so Marlo and I just started playing like a hot potato where he would say something and we would be like, something like what? Right. So you're like, I'm trying to come up with something that doesn't like reveal the case or anything. But if you're like, the person was speeding and you're like, speeding like what? Like a bat out of hell. We're like, oh, cool.
Metaphors. Yeah.
Right. And so tell us more about that. So as we were trying to come up with the complex principles where Marlo and I are like, well, we understand, but we're not sure a jury is going to understand. So, explain it to me using a story. And then we came up with stories. And so we actually taught the expert the difference between when you're teaching, your nonverbals look like this. Now you are going to look at the jury and you are going to breathe well. And we taught the authoritative voice tone. And this is what's really important. Now it reminds me of with my kid, we went surfing, right? And so now they're telling a story that illuminates that point. And so we were able to work that through instead of the script. The point that needs to be made in order to support this opinion is X. And that's the principle of why this thing that was done was wrong or why this thing that was done was unfair. And once we understood the principle, now we can just have a conversation about that principle.
I love that. And it humanizes them too.
Yes.
And for the jury.
Oh, it was so fun.
Yeah, in that particular case, there were a lot of kind of complicated concepts, right? And so we really work with that person on coming up with what's an analogy? What's that like? Right? And it was really fun, actually. We really enjoyed that process.
So levels of listening is something that you said was important in witness prep. And I think our attorneys are like, what? What does that mean? Levels of listening.
Oh, you're pop quizzing me now. So there's basically 3 levels of listening, right? So level 1 is what's actually being said, like the mechanics of the conversation.
Well, and listening to yourself.
Correct. Like inside my head, I'm already thinking of the next question. Level 2 is actually being present in the conversation.
The kind of listening we think about when we think about listening.
Right. And then level 3 is sort of what's in the air, right? And so we did an exercise with the witness where we sort of asked very transactional questions, like, tell me something important in your life. And they picked something. And I asked very transactional questions to the point where they were very confused because we had been having rich conversation. And all of a sudden I turned into a little bit of a robot. Like, when was that? And how many times did you do that? And what were you wearing when you did that? What city was that in? And I was very confusing. And I said, tell me that same point again. And they said the same point again. And it's like, what made you want to do that? Or when that was over, how did it make you feel? Or what would you share about that with somebody who is thinking about doing that? And we just dropped into this conversation. Like almost you could feel like the breathing got very deep and resonant. And there was like very intense eye contact. And it was this very beautiful moment. And of course, we sort of broke that moment and said, that's what resonance feels like. And so as you're trying to make the points, the bigger points, not the transactional points in your case, but why what happened was wrong, we want to dive into one of these stories or these vignettes in order to try to feel that place of resonance. And once they felt it, we literally were like, where do you feel that in your body? Like once they could feel that resonance, it's like, that's a mic drop moment in a courtroom. And that's what we're trying to get at. And that's what we mean by advocacy. You're not saying the words and we must win and we are right and they are wrong, but you believe so strongly in the opinion that you've formulated that those moments can come up organically in the conversation.
Well, and they show up, when I'm understanding you correctly, they show up in the level 3.
Correct.
So instead, and again, level 3, really you can think of it, level 3 as atmosphere. Right. So it's we can talk about it when, we're going to do a trial lab this week. And it's like, ooh, just notice what happened in level 3 right there. Right. The atmosphere changed. Something changed. And so I think what you're saying is so important is that instead of hitting them over the head with something, that when you have these resonant conversations, the jury gets it and it's in the atmosphere versus being convinced or persuaded.
Exactly.
Is that what I'm understanding that correctly?
Yeah.
We want them to draw their own conclusion. But again, I don't want them, the beauty of the resonance or the level 3 is they're not actually drawing the conclusion in their head. It's like they're drawing the conclusion in their heart. Like it's a feeling. It's like, ooh, like this person really believes what they're saying. Like this person really, like, I get it. I get why this is important.
And that's what's persuasive.
Yes.
Is when the person is real and can connect to the jury in that way. And how interesting that we'd be talking about resonant conversations in expert witnesses. But here it is, and you guys just lived it. As we close out today, I think this has been so helpful, and hopefully it's made all y'all realize we need to do witness prep differently, and that Jody and Marlo are amazing, and you need to have them come and help when that makes sense, of course. What would you two say is the overreaching or the overarching goal of witness prep with an expert?
The word that pops to mind for me is empowerment. I want the expert feeling that feeling we talked about earlier, where they're empowered to go in and do their job, which is these are the opinions and this is why they're right. And here's, why you, the jury, should make this decision. But I want them to feel empowered to stand behind that and really plant their flag.
Love that.
Yeah, I think the word that comes to mind for me is trust. So the expert, if they understand their role, I think they trust that they can do that role, they can fill that role. And it also goes back to this practice piece, right? If you are willing to drop your act, your professor act, right? And trust that when I show up as me with this jury as authentically myself, I'm going to connect with them and they're going to get it.
That's a self-trust and a trust
Right.
of the jury.
And a trust of counsel, frankly, because if you're practicing being, being real with the attorney you're working with, then you're going to develop that trust.
Which I think is another reason why we practice, right? We say even though we don't have our openings memorized here at H2H, we practice, and we say to have the words in your mouth, to not be stumbling, to get it into your muscle memory, and so that practice is so important, not only to really go, okay, here's what this conversation should look like, but make that connection with the attorney. Yeah. I think it's very, very different. I do remember you saying afterwards that this witness had said he had done many, many witness preps before. And what did he say about the witness prep that you guys did?
He said this far superseded any other experience.
I think he used the word mind-blowing.
He did.
I remember right.
That's right.
Yeah.
He said it was mind-blowing.
Because it was so different.
It was not what he expected, right? I think that they expect us to come in and be like, I don't like that suit. You can't wear that watch. You're sitting funny. When you cock your head to the left, it means you're lying, right? I think they were expecting that type of feedback and interaction. And we sat down and we're like, what makes you want to be an expert? And it was like, okay, well, we're hitting the ground running. So after 2 days, we were bonded, and it was a different experience. For sure.
Love it. Well, thank you to both of you for being here and talking about this very important topic. It's so fun to expand the method and now get into some of these other areas and go, whoa, what we were doing in voir dire works over here too in this way.
Yes.
So thanks for being with us, and we're going to see you again very shortly.
Thank you.
Thank you.
Yeah. Have you ever wished that you knew what the jury was thinking? Well, grab a pen and paper, because I'm about to give you instant access to a free training I created for plaintiff trial attorneys called 3 Powerful Strategies to Help You Read a Juror's Mind. It's going to help you to understand what the jury is thinking so you'll feel confident to trust them and yourself in the courtroom. Ready for the address? Go to sorryswears.com/jury. Enjoy.